Most Americans are aware that the Fifth Amendment forbids compelling a person to testify against himself or herself in a criminal trial, and any fan of TV police dramas knows about the Miranda warning, which reminds suspects of their right to remain silent. But do you know what Miranda really means and when the police are required to provide it? As part of the 1966 Miranda decision and subsequent reinterpretations, the Supreme Court has concluded that it is only necessary for police to read the Miranda warning to suspects upon their actual arrest and formal interrogation. Prior to the combination of those two events, no warning is required, and most police departments now train their officers to delay the warning until just prior to the suspect's formal interrogation, which gives the suspect plenty of time to say something incriminating. If at any point the suspect does invoke his or her right to remain silent, it officially ends the police's right to a formal interrogation, but it doesn't end their right to use any statement that was voluntarily given before or after the Miranda warning. So we know that we have the right to remain silent, but it begs the question, what does it take to invoke that right? Is it enough to simply remain silent? Well, the answer is no. In 2010, the Supreme Court decided that simply remaining silent wasn't the same thing as explicitly invoking your right to remain silent with a clear statement. Without that statement, police have the right to continue their formal or informal interrogation for hours in the hopes that you'll eventually say something incriminating. Knowing that, after making the four-part statement to the police, you should state very clearly, I want my lawyer present before I answer any questions, and until then, I invoke my right to remain silent. Keep in mind that even if you've been given your Miranda warning, and even if you've explicitly invoked your right to remain silent, anything that you say voluntarily, what's called a spontaneous statement, is admissible in court. In other words, it isn't enough just to invoke your right to remain silent. After that, you'll actually have to be silent. Another important right that you have is the right to be free from unreasonable police searches. The law allows searches without a warrant, subject to only a few exceptions. One of those exceptions is where the search is conducted with the consent of the person whose property is being searched. When asked if you consent to a search of your person, your vehicle, or your home, state very clearly, I do not consent to a search of my person or my property, and repeat that as often as necessary. Experts have concluded that there is zero upside in agreeing to a search. That said, do not interfere with the police if they choose to go ahead with a search anyway without your consent. Now, the police will frame their question to you in a way that makes it sound as though it's a foregone conclusion. For example, they won't ask, do you give up your rights under the Fourth Amendment of the Constitution? Instead, they'll say something like, it's okay if we look through your car, right? Your answer needs to be no. The problem with consenting to a search isn't just what will happen if the police find something illegal. In the hands of the prosecutor, even legal items can taint a jury. For example, a box of ammunition found in your home or car could be presented as the defendant had enough ammunition to kill 50 people. Or a pain pill that was found under your front seat that was prescribed to you 3 years ago could be framed as the defendant was found with illegal prescription drugs. Keep in mind that the laws protecting us from illegal search and seizure are designed to protect the innocent, not the guilty.